Hi everyone, my name is Samaya Khalik and I'm an immigration attorney, and we're back starting the new year 2022 with our first live discussion for the year. And I'm very excited about this topic. It's something that has caught the attention of many people over the last few years, especially during the pandemic. Today's topic is 90-day fiancé visa. So this is something many of you may be familiar with based on the shows that are around about this topic, and some of you may even know some of the requirements, etc., whatnot. But today what I'd like to do is Oh, I think I lost you for a minute. Okay. So as I was saying is today what I would like to do is actually go over the requirements for a fiancé visa here in the United States, and what you need to know in order to get that visa, who is eligible to apply, the process, the benefits, etc., whatnot. So I'll go into all of that. This is a very interesting option because in the United States, we have a lot of people coming in who petition for their spouses. But the thing is, you also have an option to petition for your fiancé. So you can option for someone before you're even married to them. The question is, who can do that? We know that U.S. citizens and green card holders have different, they have access to different things, right? They are different possibilities for them. And of course, U.S. citizens have more options available to them than green card holders. And one of the options that U.S. citizens have that green card holders don't have is the ability to petition for their fiancés or fiancées who are living outside the United States. So that's very, very important. Only green card holders can petition for their fiancés. Only U.S. citizens, let me just make sure I said that correctly. Only U.S. citizens can petition for their fiancés. Green card holders cannot. And you cannot petition for your fiancé who's here in the United States. It has to be for somebody who is outside of the United States. Also, there are a couple of other requirements, such as that you have to have the intention to marry them here in order to use this visa, as opposed to intending to marry them outside of the country. So let's go a little bit more into this visa. What is it called? It's called the K-1 visa. This is the visa that you're going to apply for, and it's generally known as the 90-day fiancé visa. Why is it known as the 90-day fiancé visa? Well, we're going to go into that in a little bit. So we discussed who can apply. U.S. citizens, they can petition for their fiancés. And what is the process? The process is that a U.S. citizen sends a petition called the I-129F to USCIS, and they wait for that to get approved. Once that's approved, the fiancé will go for an interview with the National Visa Center. They will send the application. You'll go to an interview at the consulate. If it gets approved, you will come over here, and then you have 90 days to get married to your U.S. citizen spouse or fiance, hopefully, who becomes your spouse. If you don't get married, there are certain consequences that follow. So what are the basic eligibility requirements for your fiance and you to meet before you can even submit that petition to USCIS? The first thing is that we already discussed this, you're a U.S. citizen. The second thing is that you intend to marry each other within 90 days of your fiancé entering the United States. And the third thing is, and this is very, very important, the two of you are both legally free to marry. What does that mean? It means that you're not married to other people, or that one person hasn't yet gotten divorced. This is actually a real problem that comes up. Sometimes we have people who get married to someone, and it turns out that either culturally or religiously, they're married to someone else. So that marriage to the person they're petitioning for isn't considered valid. So this is a real problem. So make sure that whoever is your fiancé that you're petitioning for, they are actually legally free to marry you. Otherwise, they're not going to get this. You're not going to get this petition approved. The other thing is that you and your fiancé must have met each other at least once within the 2-year period before which you file the petition. So this requirement is there to make sure that you're not just filing for any random person, that this is someone you actually know, you met, and that's why you are interested in marrying them and you want to bring them over into the United States. Does this mean that if you don't meet your fiance within the 2 years before you file this, you can't apply? No. And the reason for that is there are a lot of people who do get married to people that they didn't meet in person, but they have gotten to know over the phone or video, etc., whatnot. But that isn't sufficient enough. You have to show that there's some reason that keeps you from meeting the person in their home country within that 2-year period. So it could be because of cultural reasons or religious reasons or because of extreme hardship. So you have to show that maybe within your religion or your culture, people have arranged marriages or people get married to each other, they get engaged without really meeting in person. The families arrange it or it's custom to do so, and this doesn't invalidate the legality of the marriage or that it's a real marriage. Or you have to show that you going to that country would be an extreme hardship. So what would be an extreme hardship? Let's say if you had a medical condition that prevented you from traveling, work, or finances. Let's say your fiance lives in a country where the plane ticket costs like $2,000 and you don't earn enough to cover the costs of that plus go and visit. So you can show a combination of things that cause you an extreme hardship. It's not enough to just say that I can't go because I'm busy. You have to make sure you document the reasons why you can't go in terms of how you'll suffer extreme hardship or why you meet the exception because of a religious reason or a custom according to your culture that prevents you from going in person to meet the person. If you meet this requirement, all of these requirements that I listed above, you can certainly apply for the K-1 visa for your fiance, and most likely it will be approved. What's really important in putting together all the evidence is establishing that this is going to be a real marriage. So what are the type of things that you want to include? You want to include maybe some affidavits about how the two of you met, your interest in marrying each other, definitely some identification documents. So you want to establish that this is a real connection and not just some random person you met online or wherever that you are trying to bring over here. Additionally, keep in mind that when they go for that interview at the consulate, they have to bring documents with them that establishes this is a real connection and that you do have real intention on getting married when you're here in the United States. So what are some things that you can do? Again, affidavits are good, maybe some message exchanges, maybe some plans that you've already initiated to get married once your fiance enters the United States. 90 days, it's about 3 months. That's really not a lot of time. So if you're the U.S. citizen, what would be a really good idea is maybe you get a venue. Maybe you've invited people and you have a wedding invitation. Indicate that there are some plans already in progress in anticipation of your fiance getting this visa approved and coming here and getting married. So if you can establish that you meet all of these requirements to first be eligible for the K-1 visa and that you have the actual intention to get married, the K-1 visa will be approved and you'll be able to come over here. There is a possibility that they don't believe you meet all the requirements and that there is a real intention to get married and the petition may be denied. If that happens, you do have the option to apply again. So that is something to consider. That's why it's very, very important to avoid that you meet all the requirements and you submit all the evidentiary documents. So let's talk about what happens after they're here in the United States. So first of all, as we know, with this title and name that's attached to this visa, once they're here within 90 days, they have to get married. And once they're here, they can get a work authorization. So this is really great, but that work authorization is only valid for the duration of the visa, for the 90 days. And then they have about 6 months, the 90 days to get married, and then they have the 6 months within which, if they're not married, they have to leave. This is really, really important. If you're here in the United States, so we'll talk about what happens if you don't get married first. If you're here in the United States on a K-1 visa and you do not get married to your U.S. citizen fiancé, you have to leave. You can't change your status. If you stay past the authorized time period, you will start to accrue unlawful presence, and you will be subject to various immigration laws that will affect your eligibility for future visas. So if you do not marry your fiancé, your U.S. citizen fiancé, and you are the person here on a K-1 visa, it's highly recommended that you leave the United States. Let's say you don't marry the person within the 90-day period, but you end up marrying that same person a few months later. That's fine. That's still allowed because that's the person that petitioned for you. That's your U.S. citizen spouse. But can you get married to someone else and not the person who did the petition for you? No, because the petition is tied to the U.S. citizen fiancé who petitioned for you. That's very, very important. So now that we know the consequences of not getting married to your U.S. citizen fiancé, let's talk about the positive things. So once you're here on a K-1 visa, or once you brought your fiancé here over on the K-1 visa, within the 90 days, you get married. That's wonderful. Congratulations. So once you're married, you can now apply for your U.S. citizen spouse to adjust their status, which means to apply for permanent residence in the United States. And this is really great because when you file the adjustment of status application, you can also submit another work authorization application and then also a travel permit. And then after you submit these documents within about a year or so, you will go in for an interview where you will establish that you are actually indeed married to this person and you have a real marriage, after which you will be granted a green card. And then, of course, one of the other benefits of being married to a U.S. citizen is after 3 years of marriage, you will be eligible for citizenship if you're still married to the U.S. citizen. An important thing to remember is that when you are here on the K-1 visa, and you do get married to your U.S. citizen fiancé, who then becomes your U.S. citizen spouse and petitions for you, you will get a conditional green card. So this will be a 2-year green card. And the reason for this is your marriage was less than 2 years old at the time that you were granted the green card. So within 2 years, 90 days before the 2 years, and the temporary green card, conditional green card expires, you have to petition to remove the conditions on your green card in order to get the 10-year green card. That's something very important for you to remember. And then, as I was mentioning earlier, yes, if you are married to a U.S. citizen for 3 years, you'll be eligible for citizenship. Keep in mind that even if you do file the petition to remove conditions and you get the 10-year green card, if you're not married to a U.S. citizen, at the time that you reach the 3 years, you can't apply for citizenship. You have to wait the 5 years. And you can learn more about the citizenship requirements in one of our previous discussions and also more on our website. But going back to the fiancé visa, this is really an excellent option for people who have met somebody while they were overseas, maybe on a trip or something, or maybe they didn't meet that person directly while they were on a trip, but through a family member, and they're interested and they're serious about getting married to this person. And instead of having to wait, and go to that home, the fiance's home country, plan everything there, you can bring the person over here and you can get married over here. And it's really a nice option that's not available to everyone, but it is available to U.S. citizens. And it does lead to a green card for your spouse once you marry them. So that's something that is very, very nice and is an option that is great for U.S. citizens to utilize. One of the questions that we have over here is someone asked, is this a long process? This doesn't have to be a long process. It varies depending on the service center that your application is with at USCIS. So it could be anywhere from about 7 months, 5 to 7 months to a year, maybe less. It just depends on what's going on with USCIS. And in the last year or so, there have been significant delays. So do anticipate that it could be as short as a couple of months, or it could be much longer, up to about a year. But compared to some other petitions, this is actually one of the faster ways to bring somebody over here, and it doesn't take too long. So first, that's getting the petition with USCIS, and then afterwards it's the process with NVC to get the visa. That part can also take a few months, and because it's a US citizen who has petitioned for you, there isn't a long wait period. It will directly go to NVC. So that's also very nice. So in total, it's a very short process compared to other visas in terms of bringing over the fiancé. And then once you're here and you do the adjustment of status after you're married to apply for the green card, that can take about a year to get the interview and then to get the green card. Sometimes it's a little bit less, sometimes it's a few months more, but generally on average, it's about a year. One of the other questions that we get very often is, can I bring any dependent children of the fiancé to the United States? Yes, you can. If your fiancé has any unmarried children under the age of 21, you can also petition for them, and they also get the same benefits. Once they are here and their parent gets married to the US citizen, they can also become eligible to adjust as well. Let's see what other questions. Yeah, I think this should address most of the questions that come up. This is a great option if you don't want to go and marry somebody and then petition for them. If you know you already want to marry them and you want to bring them over here and then marry them over here and go through the process of petitioning for them to get a green card. I hope this clarified on a lot of the questions that you have for K1 visas. This is an actual visa that exists. It's not just a show that was created for entertainment. This is an actual legitimate visa that exists in the United States for US citizens to petition for their fiancés. If you are interested in learning more about this visa and answering specific questions, such as if the fiancé that you want to petition for has a complicated immigration background, etc., whatnot, you're welcome to contact us through our website at www.kalikalaw.com, and also read through our blog posts, etc., whatnot. And feel free to send us your questions, and I'll be happy to address them either in future posts or live discussions. I hope you have a good night, and please join me for future discussions moving forward. Take care and good night. Oh no.